we're going to be looking at how do we take all these rules and regulations and law and how do we reflect those in practice to procure AI solutions. You know, how do we partner with AI developments, AI developers to create contracts that allocate the risk across all these different regulations and laws that you've just heard about. Mikesh, do you want to introduce yourself?
Sure. Hi, everyone. I'm Mikesh. I'm one of the co-founders and CEO at Albus Health. My background largely lies in mathematics and computer science and a little bit in investment banking. But thankfully, I left, got back to technology. And in 2017, we started Albus as a spin-out from the Department of Respiratory Medicine and Biomedical Engineering at Oxford. Fundamentally, we help pharmaceutical companies collect objective data in their clinical trials. And we do that using this device, which sits on the bedside table and automatically measures vital signs, sleep, cough, and a range of other metrics without anyone needing to do or wear anything. The way it works is, sometimes when you walk into a room like this, which has automated lights, there are sensors in the corner which pick up your movement and turn the lights on. We use similar sensors to pick up the small movements in the body when you breathe, and then use signal processing and AI algorithms to measure the respiratory rate. We can even pick up the micrometer level movements in the body when the heart beats, which are invisible to the naked eye, and then detect the heart rate as accurately as a 3-lead ECG. So as you can imagine, there's a lot of value that a lot of us can get from this. We're starting with pharmaceutical clinical trials. Just to give you of how things have evolved for us, if I flash back to 2 years ago, on the 11th of November, or 12th of November, it's the 12th today? Yes, 12th of November 2023, we did not have a product. We did not even have a valid quality management system. We had no clients. Fast forward to 12th of November 2024, we had rolled out a quality management system. We had signed up a pharma company as our client, and we had shipped to a few sites in the US. Fast forward to today, we are now supplying to 2 of the world's top 10 pharma companies, and the devices are scheduled to be shipped to 23 countries across 6 continents. And in the scale, we're learning a lot of new things and a lot of different stakeholders that we're interacting with. So hospitals, universities with who we partner, sometimes to develop models, local and international regulators who our data or our products or the outcome of them come in contact with, and also large pharmaceutical companies with rigid quality management systems and policies that we have to work with, sometimes around with their support. Even in terms of the scale, 2 years ago, we were looking at, storing data for a year or 2 would be a lot of time. We now have policies which require us to store data for 25 years. There are terabytes of data being collected every day. And as you can imagine, 23 different borders to cross and 23 different sets of regulations to abide by in terms of data. So looking forward, it was very helpful, the first few chats. Thank you so much. And a lot of things for me to learn. And I'm sure more from Sarah later today.
Right, so setting the scene. Why partnerships matter in AI for medtech. So why do partnerships matter? I'm just going to say a few words and then I will pass it over to hear the practical side of creating those partnerships from Mikesh. So think of AI systems as collaborators. They're not just tools, they're actual collaborators. And these collaborators, just as human collaborators, come with obligations, risks, and responsibilities, many of which set out in regulation and various acts. So if we think of them as these collaborators, collaboration comes at a cost. We know it does from human collaborators. And then if you think that you're taking these AI models from scratch and you are educating them, you're feeding them data, you're training them. Partnering helps with the innovation at an achievable price. So general purpose AI, well, we know the cost of general purpose AI. We see that, we hear about that in the news. The scale they educate those AI models, they still can't get enough data. And then you think about specific purpose AI, smaller, targeted, focused, but then you have quality scarcity to get the right quality of data for this topic that you're training the AI for. So that's why partnership matters, getting the right partner to do the job for you, to work with you. But these partnerships are complex. Whether they're long supply chains, that adds complexity, it adds an extra security risk as well. And AI suppliers tend to be long supply chains, but they're also complex in what they do. So you have both there. So these are complex partnerships. Now, when dealing with complex supply chains, I like to break it down into data infrastructure and digital infrastructure. So let's think about the data infrastructure first. Data is likely a mix of data you've bought in, external data licenses, and it may also be homegrown data. And there may also be the pre-trained data of your AI coming into the mix. And also when you think about AI in your supply chain, there could be AI at multiple levels of your process. I mean, for example, you may use AI to do a variety of tasks like tagging your data, for example. And yes, also you will have the AI, which is the solution that's going to ingest that data. And of course, your suppliers will also have their own AIs running at different levels of the supply chain. So we can use contract to allocate risk around the data and AI governance issues that we've talked about most of this afternoon when partnering with our AI developers. And then finally, we must quickly think about digital infrastructure. AI runs on physical systems, data centers, laptops. These are real world physical systems. And so you have to think about the security of those systems. Also, you have to think about the power that's used to make sure those systems stay up. You've got to think about the connectivity of those systems to make sure they are connecting. And also, when you think about those systems and the security of your own cloud systems and your own back office, you have to bear in mind that your suppliers will also, you'll need to think about the security, not just of the AI solution that your supplier is providing, but also its back office solutions that may connect into its solutions or could just bring the whole thing down as well. So again, you have to think about not only your own issues around your own security, but also those of your suppliers down the chain, and also the concentration of the same players down the supply chain as well, providing back office solutions, often supporting these AIs. And again, contract, to some extent, can allocate risk and help you manage your risk around the governance that you have to put in place to keep the security, to resolve all these points. So, Mikesh, real world example. Let's have the AI developer perspective.
Sure, yeah. You spoke about how the supply chain of data or models needs to be assessed, right down to when the data was initiated to when the annotations or the labels were initiated. There are also obligations. So let's say we do this to our suppliers. But when we think of our clients, they're also doing the same to us. And when we work in a regulated industry like life sciences or medical technology, there is a very rigorous assessment that is done on vendors. So our pharmaceutical clients do that type of assessment on us before they choose to get us anywhere near their patients or anywhere near their clinical trials, of course, for good reason. And a lot of this is built in quality management systems. I think earlier there was a mention of having the right quality management systems, having Cyber Essentials, Cyber Essentials Plus, eventually ISO 13485 and 27001. Some of them have always required the person who is owning the quality management system or the entity owning the quality management system to understand the supply chain and its risks very well. Contracting, again, very important to ensure who owns the data and who has permission to do what with the data. We were a part of a consortium on a project by the Department of Health and Social Care as a part of the AI in Health and Care Award. We were working with Imperial College London, Royal Brompton, Birmingham Children's Hospital. And this was a fantastic project. We published the data last year to show that we can detect asthma attacks in children up to 5 days before they happen, all using the tool where children don't have to do or wear anything. It just sits on the bedside table and measures data. There was a lot of work that went in before we could do this. A lot of that was around who would own the data, what can we as a commercial organization do with that data? Can we train our models with that? Do we have commercial rights on that data? And we were actually advised by Penningtons, so Chris and his team. Chris is here. And it was very important, looking back, we were very grateful that we spent a lot of time spelling it out in very clear detail. As someone who was owning the project, it was very important that I understood what we were signing up for. So that's an example where you can call this as a collaborative partnership where data was being created as a part of a collaborative project, and it's now gone through multiple organizations, and it's doing great things for patients. That's what we all want. Ultimately, at the end of the day, we want patients to benefit. All the regulations, all the policies are always there to benefit patients, and having done them the right way has helped a lot. There's the other side of this where we are now vendors to our clients. We do have AI in our system, in our offering, and they ask a lot of questions about where the data came from. Is there any bias in the data? Who owns that data? Is there any of our clients' data that will ever leave our organization to train external models? We don't do that. So we've built systems in such a way that we own the entire AI stack. Once we get something externally into our company, we make sure that the licenses are in place for us to be able to do that. But from then on, we control them, and we control what data goes into it, and the outcome is verifiable. The V&V framework still applies, verification and validation, and we're able to generate the evidence of verification and validation of those models, which then helps take it downstream.
Excellent. So now we're going to look at dual perspectives, customer versus vendor priority. So I'm going to look at it from the customer perspective, procuring AI, and then we will have Mikesh talk from the vendor perspective. Advising a customer who's procuring AI, one of the first things you would do, even before you start your contract negotiations, is you would do your due diligence. Because there are many vendors in the space. Some are obviously very, very focused on particular problems. Others are perhaps less effective. So how do you go about this? Well, the UK AI framework has a lot in common with the GDPR in many ways, because it talks about principles such as security, transparency. It wants fairness, accountability, and contestability. And you can't go wrong, really, if you take the ICO's GDPR, the DPIA template for doing a data protection impact assessment, and use that to think into the corners of your project. Understand the who, what, where, when, why, and how of what you want to achieve. This is a very good way of looking at gaps that you hadn't considered. And as you explore how the AI will actually be used and what your use cases are, irrespective of whether the data is personal or not, it just allows you to think into the corners of that project. And that becomes your foundation for creating a map of your data flows. You've identified them all through the risk assessment, and then you map them to understand where in the world you think the vendor is going to have them. And it gives you a good basis for asking all the questions you need to ask. And that helps you build your data protection impact assessment, even though it's not personal data, as I say, but it's just a very good tool. So once you've done that, you can identify the risks, the high risk processing, and then you can decide how you're going to mitigate this through the contract that you're about to start negotiating. I mean, for example, procuring AI for legal work. One of the great things about AI is very good at research, doing briefs to counsel. It is not very good at doing contracts, in fact, because they're not linear documents. They have mechanisms, and so it doesn't have reproducibility in it. So these are the sorts of things for your project you'll be exploring and just identifying the use cases and the risks there. Mikesh, would you like to just comment on the due diligence aspect of these things at all?
Yeah, there is due diligence that we as vendors go through before we can supply to large pharmaceutical companies. Before I talk about that, just if there are any fellow entrepreneurs or developers in the room, and a lot of this is sounding like, wow, there's so much that we need to do. It's not all that complicated, and each person in the organization doesn't need to know everything. You need to have someone in the organization who can bring in the right quality management systems, set up the right processes, and then train the rest of the company. a lot of the requirements on protection, security, have been around for some time. So it's not that suddenly that we're dealing with in this AI world that everything is new. There is some additional work that needs to be done if you're dealing with an AI system, but it's all manageable. So I hope you're not leaving this room today with more anxiety than you came in with. It is all doable. It's all manageable. Now going on to the vendor due diligence, when a client is doing due diligence, typically they're doing due diligence on policies, processes, and then evidence that we are following the policies and processes. It's a classic way of doing due diligence. It starts with the quality management system and then goes on to the evidence. An additional layer of due diligence that happens is now on any AI systems, as I mentioned earlier, where the data comes from. Is there any bias in the training data? Are we aware of the biases? Who owns that data? Do we have the right permissions to use that data? And do we have permissions to do with that data what the contract requires us to do? Then there are contractual clauses where there may be things that we can and cannot do with the client's data. This is particularly important if we're working with pharmaceutical companies who themselves have to be answerable for what they're doing with their data. So this will also fall into some of the due diligence. They want to make sure that there are processes in place where data can be controlled, access can be controlled. Any new versions of the model are well documented, things are reproducible. I would say these are some of the core tenets of the due diligence.
I think that sounds great on the due diligence side of things. So now let's have a deep dive into exactly what you just mentioned, the licensing of the data and the ownership of IP. When we're talking about AI, a good way of breaking this up is to think of the input data, training data, and then think of the AI model itself, and then the output data. So the legal frameworks for data sharing and IP rights in collaboration, this is from the customer perspective, we'd want to know about the sort of data that you'd used when training your database. Mm-hmm. And from a copyright perspective, whether the proper consents were in place, etc. For example, when you're licensing in data yourself, you can license in data fields, and some of the key things you'll be looking at there are accuracy of the data, provenance of the data, right to license that data. So you would seek your own. If it's a third-party database, you would have a data license on that. Now, I should mention there is no intellectual property per se in nuggets of data. However, we tend to use copyright language nevertheless when we are licensing data. So if nothing else, you create a contractual obligation around what you do with that data. You would also look at confidentiality, of course, which is a key thing to make sure that whatever data is being used by your AI provider, you want to make sure that, again, all of that has been covered. It has the right to disclose any data that it's using. I think the other thing we would probably touch on are database rights. So often input data can be extracted from vast databases. Now, if these are, for example, external databases where skill and effort has gone into creating them, you could well be falling foul of the database rights. We have them here, they have them in the EU. Now, Tom talked about this and he made the distinction that the database rights, of course, if it's AI-generated data or machine-generated data, it probably won't fall within the protection of the database rights, and it looks like the Data Act's going to clarify that. However, if you're scraping data from the internet or from available databases, you could be caught by it. So it's an important thing to make sure that you have the right permissions to extract and reutilize that data as well. Another thing I suppose you need to think about when you are procuring the AIs is to make sure that your developer is confident that it owns and has all the IP rights in place. So a key down to the warranties. Now, the warranties are developing in these contracts quite well. I keep seeing all sorts of variations of how we procure AIs and the different types of warranties that I see coming through in contracts. And in fact, most recently, I noted that there was nothing offered on liability for copyright or database by applying the AI model, because the view was taken that there was no content in that model. It was, in fact, there was no data content in it. It was, in fact, a matrix of probabilities. And it would look like the Getty case is tending towards that. And then finally, we've got the output data. Now, it does look as though the liability, according to this most recent case, although there have been cases in Germany that seem to be going the opposite direction, but the most recent case suggests that the liability for using AIs is shifting to the output data, the user who's applying the data. So the Law Commission has issued a paper very recently looking at liability for the output of AI systems, and it acknowledges AI supply chains are extremely complicated. And so it finds it very difficult to, it's basically saying you have to look at it on a case-by-case basis. I mean, obviously you have a duty of care to patients. So when applying it, for example, AI diagnostics, it may be difficult to show there was actual negligence if you went through the sort of process Mikesh and I have just discussed, which is making sure you do a thorough due diligence and you have taken reasonable steps. The law of product liability will probably help, and that will have a role when you're looking at the AI developer manufacturers. But again, it's still not clear what the duties are vis-a-vis those in the supply chain, between each other and between the patient. Because, of course, the healthcare provider has immediate control over the AI, but little control over the design and the development of the system. And equally, the developer, it might not be in Mikesh's case, who have a very contained AI, but in the case of many developers, they may have a lot of, they design and develop, but they might not have a lot of control over the actual data, which may come from a third party. So, as I say, this is a developing area of law. There hasn't been many cases testing this, but you treat it as a tool, apply your risk assessments, and you use contract to plug those gaps. So common pitfalls in contracting, I'm going to do this very quickly because I think we're coming to the end of this. Use your DPIA template, your risk assessment, to develop the specification. So if you're a customer, look at that specification and make sure it tallies with what you think you're getting by way of functionality. Because if you're not precise about the functionality of what you're procuring, you won't be able to allocate risk in the contract. Same for service levels. However you structure those levels, you want to make sure there are concrete metrics within those service levels, because again, you won't be able to allocate risk if the performance can't be, to some degree, assessed. So they're two risk clauses. Don't think that first part, this product description, is not a risk clause. It is. And the more you flesh that out, the better. As I say, same for service levels. Termination as well, that's a risk clause. So make sure it gets the attention it deserves. Often it's left to the end because it's at the end of the contract. Make sure that's up front one that you really focus on. And then, of course, the warranties, which are developing, as I say. A recent contract I saw was trying to give warranties around accuracy, and it ended up with a slider of percentages of where they felt that would fall. Again, how that's going to fall out in a court, I don't know. So, but that's a developing area. And finally, liability and indemnity, which I won't deep dive. That's a thing in and of itself.